and we don't agree with that. We think that is an abuse of discretion. In my opinion, nobody in the state assembly, nobody in the state senate want to see a late discovery sanction, being that a murder case cannot be proven because that evidence has been precluded. The state legislature did not provide a vehicle for the people to appeal a decision which we think is inappropriate, that the consequences and the sanctions are beyond what they should be. We have not been provided with a legal mechanism for appealing that. So you have basically unfettered discretion, unreviewable discretion on a court to penalize the people for a late discovery issue, which we can do nothing about. Now, we have an allegiance and an absolute sovereignty and an ability to be part of protecting the public, right? Public safety, we have to advocate for. We also represent the victims of this crime, and Emmanuel, who has been in charge of this crime, has a relationship with the family of the victim of this case. What is wrong here is that I do not believe anybody wanted to see the consequence of a late discovery being the undermining of a murder case. And so we have taken the position that, one, we don't agree with the judge, but we have been precluded from a direct appeal. So we've made some attempts to do that by a different means. And whether that will ultimately be successful or not, we don't know.
Built into it is that understanding, that presumption that there is reason to believe that a crime was committed and that the person charged committed the crime. It makes a legally sufficient case. So when you proceed in any local court, that's what you're doing. When you proceed in any by indictment, that's what you're doing. The grand jury has to find a legally sufficient case to indict somebody. If the court reviews and finds that the evidence before the grand jury was legally insufficient, the court dismisses, which is part of what happened in this case. I'm not sure if you knew that. This court had reviewed the evidence, dismissed 2 robbery counts because those 2 counts were legally insufficient. The court let stand the murder charges and the burglary charges because the case was legally sufficient. We were proceeding on that legally sufficient case with the trial. We had witnesses lined up for today to testify today in court, not knowing that we were going to be precluded from having the witnesses identify the defendant.
Curriculum vitae of all the lab technicians were provided in March. They had that all. There was no consequence to that. There was no prejudice to that.
Right.
But nevertheless, the judge says, we can't put the DNA evidence.
I mean, that was the reason, and not because of the circumstances of getting the bandages. Oh, we had the
No,
buckle
no,
swabs.
it wasn't. I don't
Yeah.
believe it was that.
Yeah.
And because we had the buccal swabs, so we had an additional DNA
Even if they had
identification
said-
of this defendant, which was legally obtained by order of this court, that we could show this, right?
The judge will say, and I believe he did say, that even as when they opened court today,
Mhm.
this office had not provided the defense with discovery information that they were entitled to.
No,
That
the
even
judge
as
said-
of this morning.
He said notice, that we
Notice.
had not provided notice of experts.
Then why not provide notice?
What does the notice do?
Well, I mean,
Hold
listen,
on.
but
hold
no,
on.
my
this
question
is-
is, if
this
that's
is-
a requirement and you
No,
know that that's being hung up on,
Right.
why not just do
I'm
it?
gonna jump in because he was. because it was simply, within a larger package that comes from the New York State Crime Lab of who the DNA technician is. That is the identified expert. So basically, they precluded all this DNA evidence because someone a year and a half ago did not pick out a particular name and send it, with a postcard. That is,
and it's actually, the statute provides that this information needs to be disclosed to the defense. All of this information was disclosed to the defense. All of it. Now, if in the initial certificate of compliance that the names of the lab technicians wasn't put in, which I agree should have been done. But all of that information was provided to the defense attorneys. They knew about it right from the get-go, right from the preliminary hearing. In this case, they knew the DNA was there. There is no lack of disclosure on these issues. What is the consequence that the initial ADA didn't write in a separate category the names that had already been provided, already been provided with the reports. So they should have just said his name again in the discovery response?
Is that what the law requires?
No, the law, as I read it, requires disclosure of this information. Read it, 245-20F. What does it require? It requires the disclosure of the reports and the background information. That's what it requires.
And that disclosure does not even require us to turn anything over to them. It requires us to make it available for them to do their own copying and whatever they choose. But we have a practice here to basically turn things over to them. We do that routinely. And when you think about this, they insisted that they didn't want a postponement of the trial because they were ready. There was no harm, there was no prejudice to them. Prejudice was required. Prejudice to them is a predicate to the judge imposing sanctions. Prejudice, they have to show prejudice in order for the court to impose sanctions or remedies. They didn't. The court didn't find any or identify any in the rulings.
Chief ADA, he simply asked for just a small window of time so that we could make sure that we had everything right. That was all that was requested.
Only asked for a month.
No, I said specifically, I'm asking for a month, we can live with 2 weeks. I asked for the court, if you give 2 weeks, we'll be fine. I actually had witnesses lined up for this trial. So if the preclusion had not happened, we would have been able to proceed with this trial. We would have put in our witnesses. We would have had a chance of convicting Raymond Snyder for the murder he committed.